Thank you, Mr. Chair. If the WOTUS rule was a member of Congress, I think its seniority number would be about 75. I've been at this issue since 2005. I think was the first hearing that I attended in this committee on the WOTUS rule. So it's been a while. Hopefully we can get to an end at some point. But my state itself is defined by its clean water, including the health of the Puget Sound, the hundreds of lakes that we have, thousands of miles of river and streams throughout the state. People in my state know rivers, streams, and wetlands are intrinsically connected, and the health of our waters and our water-related economy depend on a strong partnership with the federal government and a level playing field among its upstream and downstream neighbors, including tribal lands. The need for a level playing field was the reason why 50 years ago this committee passed the original Clean Water Act. In the 1970s, Congress specifically noted in the legislative history of the act that a state-by-state, go-it-alone approach was, quote, inadequate in every vital aspect, unquote, and left waters severely polluted. So recently, my state joined several others in highlighting to the Supreme Court Congress's deliberate decision in 1972 to replace an ineffective patchwork of state laws with the Clean Water Act. In doing so, Congress sought to protect the interests of downstream states that might otherwise suffer the environmental consequences and economic burdens of weak or non-existent pollution controls upstream. That was our shared bipartisan view of clean water for decades, a strong federal-state partnership to protect our waters, where the Corps and the EPA set a robust federal floor of protections, and states could choose to do more but not less. It was that view embodied in the Reagan-era regulations that, for the most part, have been adopted by every presidential administration since. It's also the view embodied in the Biden proposal that seeks to clarify Clean Water Act regulations after a federal district court tossed out the Trump administration rules. In 2006, the Supreme Court, though, complicated the Clean Water Act by issuing a decision that instituted the use of a test for determining what waters remain protected by the act, but the court did not agree on a single test. That's where I started following WOTUS issue in several marathon hearings before this committee and subcommittee discussing many of the same issues we're discussing today. Since the Rapinos decision, every presidential administration has adopted the two tests outlined by the Supreme Court, the relatively permanent test and the significant nexus test for determining Clean Water Act protections. The Trump administration's second rulemaking attempt abandoned the significant nexus test. The result was an unfathomable loss of federal protections in place since 1972 and no evidence that states had the desire or resources to fill in those gaps. The Trump rule defied clean water history, defied the law, and defied science on how watersheds function. Unfortunately, this rule was rejected by a federal court only 14 months after it took effect, reinstating the Reagan-era regulations and continued use of both those tests. The Biden rule recodifies the Reagan-era framework and the use of both jurisdictional tests, but also includes significant improvements and exemptions requested by stakeholders to address legitimate concerns over uncertainty and to ease compliance. The rule seeks to balance the need to protect waters and wetlands consistent with the goals of the Clean Water Act, while trying to comply with the law, the science, and various opinions of the Supreme Court. The Biden rule is not perfect, but in my opinion, it's a far better place to start for certainty, for legality, and protecting the quality of our nation's waters. Unfortunately, the recently introduced Congressional Review Act resolution to block the proposal is likely to create more uncertainty. Should this resolution become law, it has the potential to cause even more chaos and confusion. For example, if the resolution is adopted, it's unlikely to prevent the continued use of the significant nexus test, as this test is already being utilized today. However, passage of the resolution would eliminate those stakeholder-led clarifications in the Biden rule and prevent future administrations from further improving the rule unless Congress decides to intervene. Further, enactment of this resolution could block agencies from helping stakeholders comply with any new jurisdictional test that might be announced by this Supreme Court. If that were the case, stakeholders could be left with an invalidated rulemaking and a framework for a new judicially led test, but no guidance on how to apply that test in the field. In my view, that's the exact opposite of certainty and a big mistake. So I support this administration's effort to protect water quality and provide stakeholders with some additional clarity on how to comply with the Clean Water Act. So I want to thank you for the chance to give an opening statement, thank the witnesses for joining us today, and look forward to your testimony. Thank you.